Welcome back to the channel where stories unfold, insights spark conversations.
Diddy says federal prosecutors are making it impossible for him to mount a defense because they refuse to give up the names of his accusers in the criminal case against him. I need names of alleged victims. How else can I defend myself? Diddy's legal team filed new docs Tuesday asking a federal judge to direct the U.S. Attorney's Office to identify the anonymous alleged victims referred to in the indictment, so he can specifically address the allegation he abused, threatened and coerced women and others to satisfy his sexual desires. In the docs, Diddy says once the names are revealed, he believes there will be voluminous evidence the interactions with the alleged victims were consensual. He wants the feds to be more specific about who exactly is claiming non-consensual acts. The 14-page indictment only mentions Victim 1, who, based on the allegations, seems to be Cassie, and Diddy's attorneys have referred to Victim 1 as his ex-girlfriend. Diddy's new request to the judge is not about revealing her name, it's any other accusers the feds are relying on to build the case against him. Another reason the Bad Boy Records founder wants the names revealed has to do with all the civil lawsuits being filed by attorney Tony Busby, who says he now has 120 clients. Diddy's team claims the federal case has had a pervasive ripple effect, resulting in a torrent of allegations by unidentified complainants. In the docs, they make direct reference to the fact 6 of Busby's clients filed suits on Monday.
So here's TMZ expressing their thoughts on Diddy or his lawyer requesting the alleged victims' names.
There's no way Diddy can defend himself against his accusers without their names. At least according to Diddy.
So Diddy is asking a judge to order the prosecutors in his criminal case to turn over all the names of the alleged victims that are referenced in the indictment.
Because in the indictment, they don't name anyone.
Except for victim number 1, who we can assume is his ex-girlfriend Cassie.
But there are statements in the indictment about, for decades, Diddy coercing, abusing, threatening women and others for his own sexual gratification. And Diddy is saying, how am I supposed to defend myself if you don't identify who you're talking about? Because I've had a ton of consensual sex in my life.
Diddy may have a valid point, but the feds aren't budging.
Prosecutors are saying, we're not going to turn that over at this stage.
Well, they will have to at some point, right? They're just saying we're not doing it now because they're afraid that he's going to intimidate witnesses.
And with the trial not until May, there's just too much time. But Diddy's request also has to do with the civil lawsuits.
The way they say in the doc, you've created this domino effect, and now everybody thinks they can just file a lawsuit against me anonymously.
I think there are definitely people in the mix who are just making it up. And he's going to be able to say, look, this is just a free-for-all coming after my money, and they're all nonsense. And if some are, it makes the other ones look less credible also. More likely, this avalanche seems to indicate a pattern of misconduct over many decades.
So it sounds like Diddy will be given the names of the alleged victims at some point, but not anytime soon.
In the docs, they make direct reference to the fact 6 of Busby's clients filed suits on Monday. Due to the number and anonymity of accusers, Diddy says his attorneys asked federal prosecutors to identify its alleged victims, but they refused to, at this stage. A representative for the U.S. Attorney's Office for the Southern District of New York declined to comment. Diddy was arrested last month during a raid on the Midtown Manhattan hotel where he was staying. Since then, he's been locked up in Brooklyn, and the court has twice rejected his effort to get out on bail. His trial is set to begin in May 2025, and, as of now, he'll be behind bars until then.
If Sean Diddy Combs is requesting that the names of his accusers be revealed, it likely reflects his belief that knowing their identities is essential for mounting a strong defense. He may feel that without this information, he cannot fully investigate the claims, challenge the credibility of the accusers, or address any potential biases or ulterior motives behind the accusations. In some cases, accusers' names are kept confidential to protect their safety or privacy, especially in sensitive matters such as sexual misconduct. However, the accused often argues that transparency is necessary for a fair legal process. This tension between protecting accusers and ensuring they feel that without this information, he cannot fully investigate the claims, challenge the credibility of the accusers, or address any potential biases or ulterior motives behind the accusations. In some cases, accusers' names are kept confidential to protect their safety or privacy, especially in sensitive matters such as sexual misconduct. However, the accused often argues that transparency is necessary for a fair legal process. This tension between protecting accusers and ensuring the accused's right to a defense is a common legal issue, particularly in high-profile cases like those involving celebrities. If prosecutors are refusing to hand over the names of Sean Diddy Combs' accusers due to concerns about intimidation, it suggests that they fear revealing the accusers' identities could lead to threats or retaliation, which is not uncommon in high-profile cases. The prosecutors are likely trying to protect the safety and privacy of the accusers, especially if they believe there could be a power imbalance or that the accusers might face backlash from the public or others. On the other hand, Diddy's legal team would argue that in order to mount a proper defense, they need access to the accusers' identities. This would allow them to investigate the credibility of the claims and prepare counter-arguments. The defense might also argue that keeping the accusers anonymous infringes upon Diddy's right to a fair trial, as it limits their ability to challenge the accusers effectively. This kind of legal conflict is often addressed by the court balancing both sides, protecting the accusers, while ensuring the accused can properly defend themselves. Sometimes, courts may grant limited access to this information under strict confidentiality to ensure that both sides' rights are respected. In cases where there is a tension between protecting accusers and ensuring the accused's right to a fair defense, courts typically follow procedures to balance both interests. Here's how these situations are commonly handled. 1. Protective orders. Courts may issue protective orders that limit who can access the names of the accusers. For example, the accusers' identities might only be revealed to the defense attorneys, investigators, and the judge, but not to the public or even the accused directly. This allows the defense to prepare while minimizing the risk of retaliation or intimidation. 2. Anonymity in pretrial proceedings. In some cases, the accusers' identities may be kept anonymous during the early stages of the legal process, such as during grand jury hearings or depositions. However, as the case moves forward, particularly when the case goes to trial, accusers are generally expected to reveal their identities, especially if they are testifying. The Sixth Amendment in the U.S. Constitution guarantees the right of the accused to confront their accuser in court. Nahar 3. Redacted information. In cases where there are significant concerns about intimidation, courts might allow redacted versions of key documents to be handed over to the defense. This could involve blacking out names, addresses, or other identifying details in police reports, witness statements, or legal filings. The defense can still use the information to build their case, but won't have direct access to the accuser's personal details. 4. In-camera review. Sometimes, the judge will conduct an in-camera review, which means the judge reviews sensitive information in private, without the defense or prosecution present. The judge then decides which parts of the information are necessary for the defense and releases it in a controlled manner. This can help balance privacy with the need for transparency. 5. Witness protection or anonymity programs. If there's significant risk of intimidation or retaliation, courts may place accusers in witness protection programs or use other measures to shield them. This might involve keeping their identities confidential during pretrial proceedings and limiting public exposure. However, complete anonymity is rare at trial, particularly in criminal cases where the accused has the right to know and confront their accuser. 6. Closed hearings or limited public access. Courts can also conduct closed hearings or limit public access to certain parts of the trial to protect the accusers from unwanted attention or retaliation. This is especially common in cases involving sexual assault or domestic violence. These measures protect the accuser's privacy while ensuring that the legal process is fair and transparent. 7. Balancing test. Courts often perform a balancing test to decide whether to reveal the accuser's names. They weigh the need for the defense to know the identity of the accusers against the risk of harm or intimidation to the accusers if their identities are disclosed. If the court believes the threat to the accusers is high, it might take extra precautions or delay the disclosure of the accusers' names until absolutely necessary. 8. Court-ordered confidentiality agreements. Sometimes, courts require all parties involved to sign confidentiality agreements, ensuring that sensitive information, like the accuser's identities, is not leaked or made public. Breaching this agreement can result in legal penalties. In high-profile cases like Sean Diddy Combs' situation, where there may be concerns about potential intimidation due to his influence or the public nature of the case, the court is likely to consider some of these protections. However, the defense will argue that they need sufficient access to information to challenge the credibility of the accusers and provide a robust defense. The right to confront one's accusers is a cornerstone of many legal systems, especially in the US and other countries that follow adversarial legal processes. However, courts have developed mechanisms to protect accusers in sensitive cases. Here's a more detailed look at how this works, particularly focusing on US law, but similar principles apply in many other jurisdictions. 1. The right to confront accusers. Sixth Amendment in the US. The Sixth Amendment to the U.S. Constitution provides defendants the right to be confronted with the witnesses against them in criminal prosecutions. This is a key part of ensuring a fair trial, as it allows the defense to challenge the evidence, cross-examine the witnesses, and present their side of the story. Cross-examination. The defense has the right to question the accusers during trial, allowing them to challenge the accuser's credibility, motives, and the accuracy of their testimony. This is seen as essential to discovering the truth. Face-to-face confrontation. In most cases, the accused has the right to see their accuser in court, though some exceptions are made, especially when the accuser's well-being is at risk. 2. Exceptions to the right to confrontation. While the right to confrontation is strong, there are exceptions. Courts have recognized that in certain circumstances, protecting accusers, particularly vulnerable ones, may outweigh the need for face-to-face confrontation. Child witnesses. In cases involving child witnesses, especially in abuse cases, courts may allow for alternative forms of testimony. For example, children may testify via closed-circuit television, CCTV, to avoid direct confrontation with the accused. The U.S. Supreme Court upheld this in Maryland v. Craig, 1990, where the court ruled that protecting a child from trauma could justify limiting face-to-face confrontation, as long as the procedure ensures the reliability of the testimony. Fear of retaliation. In some cases, particularly those involving organized crime, gangs, or powerful defendants, courts might limit direct confrontation if there's a credible fear that witnesses could be harmed or intimidated. 3. Anonymous witnesses. In rare cases, courts may allow accusers to testify anonymously, but this is extremely uncommon in the U.S. due to the Sixth Amendment. When it happens, it's typically in the early stages of a case, such as grand jury proceedings or certain preliminary hearings, but full anonymity is not usually allowed at trial. In jurisdictions outside the U.S., such as in parts of Europe, anonymous witnesses are sometimes used in cases of terrorism, organized crime, or severe violence. But courts carefully regulate the procedure to ensure fairness. 4. The Balancing Act, protecting accusers versus fair trial rights. Courts must carefully balance two key principles: the accused's right to a fair trial. The defense must be able to access enough information to challenge the credibility of the accuser and the evidence. Without knowing who the accuser is, it can be difficult to investigate their background, motives, or whether they have any prior history of false accusations. The accuser's right to protection. In cases where there is a credible threat of harm, courts have to ensure that the accusers feel safe enough to come forward and testify. If accusers feel too intimidated, they may refuse to cooperate, which could undermine the justice process. 5. Specific cases where accusers' right identities are protected. There are certain types of cases where courts frequently take extra steps to protect accusers' identities, particularly in the pretrial phase. Sexual assault and domestic violence cases. In many jurisdictions, laws allow victims of sexual assault and domestic violence to file charges anonymously at the outset, or have their identities protected in court documents. During trial, accusers' names are generally revealed, but courts may take steps to protect their privacy, such as banning the publication of their identities in the media. Whistleblowers. In cases where accusers are acting as whistleblowers, i.e., reporting wrongdoing within an organization, courts may allow their identities to remain anonymous or confidential to protect them from retaliation, especially if the defendant has significant power or influence. 6. Notable cases where accusers were protected. Some high-profile cases have tested the limits of how accusers' identities can be protected while maintaining the accused's right to a fair trial. Harvey Weinstein case. In the case against Hollywood producer Harvey Weinstein, several accusers' identities were initially protected during the investigation phase. However, once the case went to trial, accusers were required to testify publicly. Despite this, courts took steps to protect their privacy from media exposure, recognizing the sensitive nature of their testimony. Organized crime cases. In some cases involving mob or gang violence, witnesses have been allowed to testify without revealing their identities due to credible threats to their safety. In these cases, judges often apply strict protective measures, such as closed sessions or confidential filings, to protect the accusers, while still ensuring the defense has access to relevant information to challenge the accusations. 7. Special measures for accusers in trial. Some jurisdictions employ additional methods to shield accusers from intimidation while allowing their identities to be revealed in court. Screens or partitions. In certain cases, courts allow screens or partitions to be used during testimony, so that the accuser doesn't have to directly face the accused in the courtroom. This is often used for vulnerable witnesses, such as victims of abuse. Courtroom exclusions. In some cases, the general public or media may be excluded from the courtroom when the accuser is testifying. This is to protect the privacy of the accuser and minimize the risk of intimidation from external parties. In Sean Diddy Combs' situation, if the prosecutors are concerned about intimidation, they may push for protective measures to shield the accusers, at least during the early stages of the legal process. However, if the case goes to trial, it is likely that the accusers will need to be identified and testify publicly, unless there are extraordinary circumstances. The defense will likely argue for full access to the accusers' identities in order to ensure a fair trial. Here are several notable examples of cases where courts had to balance protecting accusers with ensuring a fair trial for the accused. These examples demonstrate how courts navigate this delicate issue across various types of cases, from sexual assault to organized crime and high-profile trials. 1. The Harvey Weinstein case. Background. Harvey Weinstein, a Hollywood producer, was accused of sexual misconduct by numerous women. Many of these accusers initially sought anonymity due to the public nature of the case and fear of retaliation. Court's approach. During the pre-trial phase, the identities of many accusers were kept confidential to protect their privacy and safety. However, during the trial, some accusers had to testify publicly. The court balanced their privacy by issuing media gag orders to prevent the public or press from harassing or exposing the accusers unnecessarily. Additionally, some testimony was conducted in closed court sessions with restrictions on what could be reported to the public. Outcome. While the identities of accusers were eventually revealed in court, the protective measures ensured they were not further victimized by public scrutiny, while still allowing Weinstein's defense to challenge their credibility. 2. The R. Kelly case. Background. R&B singer R. Kelly was accused of sexually abusing numerous women and underage girls. Many of these accusers feared retaliation, given Kelly's influence and his past actions of intimidating witnesses. Court's approach. To protect accusers, especially those who were minors at the time of the alleged abuse, the court implemented confidentiality orders and allowed certain testimony to be heard without the accusers' identities being made public. Some accusers testified under pseudonyms to prevent their names from being broadcast widely. Despite this, the defense was given access to their identities privately so they could mount an appropriate defense. Outcome. Kelly was convicted, and the court's protective measures ensured that the accusers could testify without excessive public or media harassment, though the defense still had access to necessary information. Number 3. Ghislaine Maxwell and Jeffrey Epstein case. Background. Ghislaine Maxwell was charged with aiding Jeffrey Epstein in trafficking minors for sexual abuse. Many of the accusers in this case were concerned about their safety and privacy, especially given the wealth and influence of Epstein and Maxwell. Court's approach. Court kept many of the accusers' identities confidential during the pretrial phase. Even during trial, some accusers were allowed to testify using pseudonyms, and their personal details were heavily protected to prevent intimidation. The court also implemented media restrictions to ensure that accusers weren't subjected to unnecessary public exposure. Outcome: the accusers were able to testify without significant public harassment, but the defense still had access to information that allowed them to challenge the accuser's credibility. 4. Bill Cosby. Background: Bill Cosby faced numerous allegations of sexual assault, with many accusers stepping forward after years of silence. Some of the women feared retribution, given Cosby's fame and influence. Court's approach: initially, many accusers came forward anonymously, but as the legal proceedings moved forward, their identities were revealed. To balance privacy concerns, some of the proceedings, including pre-trial hearings, were conducted privately, and courts limited the amount of personal information shared in public court documents. Additionally, accusers who testified were given support to ensure their safety, especially with respect to media exposure. Outcome: the court provided measures to protect the accuser's privacy, though their identities were ultimately disclosed during trial to allow for a fair cross-examination by Cosby's defense team. 5. Organized crime cases, e.g., mafia background. In cases involving organized crime, such as trials against members of the mafia, the witnesses, often insiders or associates of criminal organizations, are at significant risk of intimidation or violence. Court's approach: in these cases, witness protection programs are often employed, and courts sometimes allow anonymous testimony or sealed identities. Witnesses in such cases may testify via video link or behind a screen to shield their identities. Courts may also seal records that contain witness names and addresses. This approach aims to protect witnesses from retaliation while ensuring the defense has access to the content of their testimony. Outcome: courts are cautious about granting anonymity to accusers in these cases, but the use of witness protection and alternative forms of testimony is often effective in ensuring both safety and fairness. 6. The O.J. Simpson case. Background: the infamous trial of O.J. Simpson for the murders of Nicole Brown Simpson and Ron Goldman garnered massive media attention. Many witnesses feared public exposure and harassment due to the high-profile nature of the case. Court's approach: while the identities of key witnesses were public, the court imposed strict media restrictions on certain elements of the trial to protect witnesses from unnecessary attention or intimidation. This included limiting the broadcasting of certain testimonies and details about witnesses' personal lives. While accusers were known to the defense and public, the court's restrictions helped mitigate the risk of public retaliation. Outcome: Simpson was acquitted, but the case showcased how courts can attempt to protect witnesses' privacy in high-profile cases where public and media scrutiny is intense. 7. Terrorism cases, international examples. Background: in some terrorism trials, such as those involving high-profile suspects like Osama bin Laden's associates or groups like Al-Qaeda or ISIS, witnesses and accusers have faced significant risks due to the global nature of these organizations. Court's approach: courts have sometimes allowed witnesses to testify under complete anonymity to prevent retaliation from terrorist organizations. For example, some European courts have permitted accusers to testify behind screens or via video conferencing from undisclosed locations. Courts balance these measures with the defense's right to question the credibility of anonymous testimony, often allowing the defense access to sealed records that reveal identities while ensuring these names are not publicly disclosed. Outcome: anonymous testimony is more common in international terrorism cases than in standard criminal cases, and these measures have been critical in protecting the accusers while maintaining the integrity of the trial. 8. The Catholic Church sexual abuse scandals. Background: in cases involving accusations of sexual abuse within the Catholic Church, many victims sought anonymity due to fear of retribution or public exposure. Court's approach: courts have often allowed victims to file lawsuits under pseudonyms like John Doe or Jane Doe to protect their privacy. In some cases, accusers' identities remained sealed throughout the proceedings, with the court only revealing their identities to the defense in a controlled manner. Outcome: many accusers were able to maintain their anonymity throughout the legal process, particularly in civil cases. while still allowing the church's defense teams to access necessary information to challenge the accusations. These examples highlight the varying approaches courts take to strike a balance between protecting accusers and ensuring the accused has a fair opportunity to defend themselves. In most cases, as trials proceed, the anonymity of accusers is limited to ensure that the defense has the necessary information to challenge accusations. But courts take extra care to minimize the risk of harm or retaliation against accusers. Here are some additional insights on how courts navigate these situations, focusing on the broader implications of balancing accuser protection with the accused's rights, and how these principles evolve across different legal contexts. 1. The role of public opinion and media influence. High-profile cases often come with extensive media coverage, which can create a difficult atmosphere for both accusers and the accused. In cases like those involving Harvey Weinstein, R. Kelly, or O.J. Simpson, the public and media scrutiny is immense. Courts may impose gag orders to prevent attorneys and parties involved from discussing case details publicly, limiting media access to sensitive information. This is to prevent outside influence on the case and to protect the reputations of both the accusers and the accused. Media pressure can also affect whether accusers feel comfortable coming forward. In cases like the Bill Cosby trial, many accusers were initially reluctant to step forward due to fear of public backlash. However, once a few accusers came forward, more followed, bolstered by a growing social movement, e.g., the Me Too movement, which encouraged more survivors to share their stories. 2. Psychological impact on accusers. Protecting the identity of accusers in sensitive cases is not just about physical safety. It's also about mitigating the psychological toll. In sexual assault, domestic violence, or child abuse cases, accusers may experience trauma reliving their experiences in a public forum. Courts may adopt victim-friendly measures, like allowing testimony via closed-circuit television or behind screens to protect accusers from the emotional strain of directly confronting their abuser in court. This is particularly prevalent in cases involving child witnesses or vulnerable adults. However, the challenge is ensuring that these protective measures don't unduly prejudice the jury against the accused. Defense attorneys often argue that such accommodations may imply guilt or suggest that the accused is inherently dangerous, potentially biasing the jury. 3. Power dynamics and retaliation concerns. In cases involving celebrities, politicians, or organized crime figures, there is often a power imbalance between the accusers and the accused. Accusers may fear not just personal retaliation, but professional consequences, especially in cases like those against Harvey Weinstein, where many of the accusers were women working in the entertainment industry. Courts recognize this imbalance and may take extra steps to ensure that accusers aren't just protected from physical threats, but also from career or social retaliation. This is one reason why, in some cases, courts allow for anonymity or sealed identities during certain proceedings. Whistleblower protections are an example of how courts and lawmakers seek to protect individuals who expose powerful figures. These protections are particularly relevant in cases involving corruption, financial misconduct, or corporate crime, where the risk of retaliation may not be physical, but professional. 4. Evolving legal standards and social movements. Legal standards around the protection of accusers are evolving, especially in light of social movements such as Me Too and Time's Up, which have highlighted the systemic challenges accusers face when coming forward, particularly in cases of sexual misconduct. These movements have pushed for reforms, such as extending the statute of limitations for reporting sexual assault and encouraging courts to take a victim-centered approach. As a result, courts are increasingly sensitive to the dynamics of power, gender, and trauma when determining whether to protect an accuser's identity. On the flip side, there is concern about protecting the presumption of innocence for the accused. In some cases, high-profile accusations can result in significant reputational damage long before a trial occurs. Defense attorneys often argue that, in today's media environment, the court of public opinion can be harsher than the court of law, leading to unfair trials for those accused of serious crimes. 5. International perspectives on witness protection. In some jurisdictions outside the US, anonymity for witnesses and accusers is more common, particularly in cases involving terrorism, organized crime, or domestic violence. United Kingdom. In the UK, courts sometimes allow for anonymous witnesses in cases involving gangs or terror-related offenses, where witnesses face serious threats to their lives. These measures include testifying behind screens or through video links. European Court of Human Rights, ECHR. The ECHR has ruled that anonymity can be compatible with a fair trial under certain conditions, but the defendant must have adequate opportunity to challenge the witness's credibility. In Canada, the courts have been more flexible with allowing publication bans that protect the identity of sexual assault survivors and vulnerable witnesses. Accusers can also request that their names be protected throughout the trial to avoid media exposure. 6. Technology and virtual testimonies. With the advancement of technology, courts are increasingly using video testimonies or remote appearances, especially in cases where the accuser's safety or emotional well-being is at risk. These technological solutions became even more common during the COVID-19 pandemic, and they may continue to play a role in future court proceedings. However, there are ongoing debates about how effective remote testimonies are in preserving the fairness of the trial. The defense may argue that virtual presence dilutes the impact of cross-examination, and it can be harder to assess a witness's credibility through a screen. Courts must balance the benefits of protecting accusers with ensuring that the accused receives a fair and rigorous defense. Potential legal reforms. Some legal experts advocate for expanded legal protections for accusers in specific circumstances, especially in cases of sexual violence and domestic abuse. This includes discussions about whether accusers' identities should be permanently protected, even after a trial ends, to avoid ongoing harassment or stigmatization. Others argue for stricter limits on pretrial publicity to protect both the accused and accusers from unfair media exposure. In high-profile cases, the intense public interest can lead to the sensationalizing of accusations, sometimes with minimal evidence. Courts may need to consider more proactive measures to limit media access before a verdict is reached. 8. Criticisms and concerns. While protections for accusers are important, there are criticisms that such measures can be used to tip the scales unfairly against the accused. For example, some argue that allowing accusers to testify anonymously or under special conditions makes it harder for the defense to thoroughly investigate the motives or credibility of the accuser. This concern is especially acute in cases involving powerful individuals, where the accused may feel that the court is presuming guilt by going to great lengths to protect accusers. Defense attorneys often argue that openness and transparency in court proceedings are essential for ensuring justice, and that excessive protections for accusers can compromise these principles. In the case of celebrity defendants like Diddy Combs, the defense may argue that accusers are using anonymity to shield themselves from legitimate scrutiny, potentially making it harder for the defendant to clear their name. 1. Balancing act. Courts continuously walk a fine line between protecting accusers, especially in sensitive cases like sexual assault or organized crime, and ensuring the accused has access to a fair and open trial. 2. Vulnerability considerations. The psychological and emotional well-being of accusers plays a major role in deciding whether their identities should be protected, with courts more likely to grant anonymity when the accuser is vulnerable or the risk of retaliation is high. 3. Media's role. In high-profile cases, media attention can significantly affect both accusers and the accused, leading courts to impose stricter restrictions to avoid influencing public perception and ensuring a fair trial. 4. International differences. While U.S. courts are typically more resistant to allowing fully anonymous witnesses due to the Sixth Amendment's Confrontation Clause, other jurisdictions like the UK and Canada take a more flexible approach when witness safety is at stake. 5. Legal reforms and debate. The legal landscape is evolving. Here are some additional insights on how courts navigate these situations, focusing on the broader implications of balancing accuser protection with the accused's rights, and how these principles evolve across different legal contexts. 1. The role of public opinion and media influence. High-profile cases often come with extensive media coverage, which can create a difficult atmosphere for both accusers and the accused. In cases like those involving Harvey Weinstein, R. Kelly, or O.J. Simpson, the public and media scrutiny is immense. In the recent legal proceedings involving Sean Diddy Combs, his lawyers will eventually receive the names of his accusers, but not immediately. This delay is part of the process that courts often implement in cases involving sensitive allegations, such as sexual assault or harassment. These measures are typically in place to protect the identities of the accusers, particularly in the early stages of the lawsuit, to prevent undue harassment or retaliation. The legal team representing Diddy will likely obtain this information as part of the discovery phase, where both sides exchange evidence and relevant details. However, privacy concerns and the sensitivity of the allegations could delay the release of accusers' names until further legal procedures ensure protection for all parties involved. Before you go, don't forget to hit that subscribe button and turn on notifications so you never miss out on our latest content. Thanks for watching, and we'll see you in the next one.